SJC-12013, Commonwealth v. Lawrence F. Maguire.
Mr. Stanton, good morning.
Morning, Your Honors. May I please the Court? Brad Stanton for the defendant, Lawrence Maguire. The issue before us today is essentially a very narrow issue, and it's whether or not the majority decision of the appeals court misconstrued prior precedent of this court that established that significant additional proof or significant extra proof, and I emphasize that point, for a conviction of the far more serious offense of open and gross lewdness over the misdemeanor level offense of indecent exposure. We're talking about the distinction here of a misdemeanor that carries a potential penalty of 6 months within the House of Corrections versus a felony that carries up to 3 years within the state prison system and all the terrible collateral consequences that come along with that type of conviction. Now, it's a sufficiency standard, and I won't belabor the standard. The court's well aware with respect to the standard that, with respect to open and gross lewdness, 272. Section 16. The statute itself doesn't establish the elements. The decisional law established by this court in cases along the lines of Kessler and the like established the 5 essential elements of the crime. Now, what I would suggest that is of great importance is obviously the 5th element, whether or not there was actual shock and alarm to one or more persons. Now, shock and alarm, by its very nature, by the definition, implies surprise on an unsuspecting individual, a victim or an alleged victim in this sense, and a substantial negative emotional result, anger, outrage, disgust, the like. Now, the decisional cases out of this court and the appeals court have said that specific words or essential words, keywords, buzzwords aren't required. Now, having said that, the appeals court decision and the government's brief rely on 2 cases, Pereira and Gray. And I think those cases are important, and I think they can be distinguished from the series of facts that we have here for 2 reasons. Now, Pereira was the case out of Sullivan Square, the MBTA train station, where an officer happened upon an individual who was in a car who was openly masturbating in public. Now, that came sort of, I'll concede the shock there, and I don't disagree with the case law in either of those 2 cases. But that's a situation where the officer actually happens upon an individual in shocked surprise as a result of his observations that he sees.
Doesn't he use I'm not sure I'm going to get the word right, but disturbed, doesn't the officer in this case and the officer in Pereira use one of those adjectives is the same? Is it disturbed or something?
It's disturbed, Your Honor. In that case, he said disturbed, and in our case here, the facts before us, it was disturbed and concerned. And as Justice Milkey had, I think, accurately or appropriately articulated in his dissent, that concern for the victims was a vicarious type concern. It wasn't a genuine concern. Now, I'm the first to concede that the officer can be an alleged victim for the purposes of an open and gross case, but based on this series of facts, I don't think it's appropriate.
Can they be shocked and alarmed because of who else is seeing this? So it can't be vicarious, but can something happen in the presence of the witness, and who's on the witness stand describing what happened, and they're describing something that constitutes being shocked and alarmed because they're so upset about seeing somebody else having to witness something. And we can get into details, but you understand what I'm talking about.
And I don't disagree with that point. I think they could. But I think the distinction to be drawn from Pereira and Gray in this case that we have here is in both Pereira and Gray, they happened upon this individual. In our case, Detective Conway was actively investigating. He was doing his job, and he did a good job. He saw something that he thought was suspicious. He recognized it wasn't criminal at that point in time, so he continued to investigate. He went, as Justice Milkey put it, he went to great lengths to actually make the observations that he did, a 1 to 2 second observation as he descended a staircase. Now, the major distinctions between those cases and what we have before us are, like I said, the shock, actually happening upon it, and then the action itself. In both of those cases, in Pereira, that was a situation where there was public masturbation, and then in Gray, that was a situation where a janitor came upon, once again by surprise, came upon 2 individuals engaged in a public sex act. Here, we don't have that. We don't have a public sex act. We don't have active masturbation. We have Detective Conway coming down the stairs, and he testifies for 1 to 2 seconds, he sees my client's genitals exposed. He's not touching it, he's not manipulating it, he's not engaged in a sex act or public masturbation. I think that's significant when we're talking about the distinction between a misdemeanor and a felony. I mean, the penalties are clear. It's a clear distinction, and this court has emphasized in Kessler that significant additional proof is required to raise to that level. And I think that's appropriate given the circumstances.
Now, this term shock and alarm, I guess, is our own, or the appeals court. It's not in the statute. Should we be considering taking a fresh look at whether shock or alarm is the appropriate measure, or should we be focusing on some measure of emotional distress?
I think that the terms could be further defined to give more guidance, but I think based on the series of facts that we have before us, I think that this court could distinguish this set of facts from Gray and from Pereira without changing that definition.
So a cynic could say that a witness could be just utter the magic words, "I was shocked," and you wouldn't have an argument.
I think the buzzwords. I think
Is
you have to look at the
that
facts.
what we reached? Is basically if the witness utters a buzzword, then it's sufficient.
I would disagree with that point. I think that would be insufficient, and I think as Justice Milkey had articulated the quote that he put on the last page of the dissent. I mean, it would essentially give the government free rein to elevate an indecent exposure to an open engross anytime they had a police officer witness who was willing to utter those very buzzwords.
Well, it doesn't, I mean, at some point, the 4th element, if that's the 5th element about did it actually shock and alarm somebody, and isn't the 4th element whether it would reasonably shock and alarm?
I think it's whether there was an intent
Intended,
to
oh,
cause
it's
the shock
intended.
and alarm.
So it's, there's no reasonable person piece of this.
But in this case, given what the officer observed beforehand, where the person was making lewd acts and touching himself with others, I think you conceded that the intent element was satisfied, the 4th element was satisfied.
I think the argument has been narrowed to
Or at least,
the 5th.
at least under the Lattimore standard.
At the appeals court level, we challenged all 5 elements. I think we have since narrowed that argument, and I think on the basis of these facts, in comparison to these other 2 cases and in many other cases, they're distinguishable, and I think there's good reason to do so under the circumstances.
So you have a situation in which the same conduct could be this crime, depending on the sensitivity of the person who is the victim. I mean, you do the same conduct before a police officer who says, "Hell, I've seen everything, and nothing alarms or shocks me anymore," versus somebody who does not see everything and may have a low threshold. I mean, I think back to the line from Anything Goes, and Dave's, I won't sing it, but a glimpse of stocking was seen as something shocking, but now anything goes. These views change over time.
They do. I wouldn't suggest that an officer is desensitized, and I wouldn't suggest to the court that an officer can't be a victim of this particular crime. I would just suggest that under this series of facts, the officer, I mean, he was doing his job effectively. He saw something suspicious, not criminal, and he went to great lengths to pursue that and actually see what was going on, and he ultimately made the arrest. But I think that's far different than what the intent, the legislative intent, and the intent of the decisional law, where it seems to me anyway that you would have to come on this and you would actually have to have some sort of shock. I mean, he can't. The officer, and I think Justice Milkey, if I correctly articulated, had said that he can't feign shock and surprise after all the effort that he went to see it. Now, the officer in the MBTA case, the Pereira case, I think he can legitimately suggest that he was shocked and surprised. He came upon it, and it was out in public, and it was active masturbation. He wasn't searching it out under those facts. So I think that it's significantly distinguishable. And same goes for
But does
Gray.
that mean that if you, as perhaps in this case, you have indication that this individual is doing public masturbation, and then you follow him in order to see him do it, and you say, well, he did it, I'm not surprised he did it, that's why I'm following him. It's not shock or alarm? I mean, I'm trying to sort of sort out how we interpret this.
I would suggest no, because I think the officer he saw something suspicious, inappropriate or innocent, whatnot, however you have it, and then he pursued his investigation. He recognized right there, because he could have arrested him on the spot for similar behavior, but he didn't. He recognized it wasn't criminal. I don't think that gets to the level that Pereira and Gray, I would suggest, do. And I think that's where we draw this significant additional proof or requirement from a misdemeanor to a felony.
All right, thank you.
Thank you, Your Honors.
Mr. Sears, welcome back.
Thank you, sir. Good morning, Your Honors. May it please the Court, Matt Sears on behalf of the Commonwealth. With me today is Assistant District Attorney Ashley Poland, the trial prosecutor on this matter. Again, this is a classic sufficiency case, and it's helpful, maybe unnecessary, but to remind the Court that in sufficiency cases, the evidence is considered in a light most favorable to the Commonwealth, and all issues of credibility are resolved in the Commonwealth's favor. In this case, the terminology, I need to correct my brother in response to Judge Botsford's question, was not that he was disturbed, it was that he was disgusted. That's the same terminology used in Pereira. There are 4 factors that exist in this case that support sufficiency and that support the significance of his emotional reaction. The first is his unequivocal statement of disgust. He stated on page 23, volume 2, "I was disgusted, period. Seeing someone else's penis is unusual, yes it is." That's what he said later at page 59. The equivocal nature of that testimony, the unequivocal nature of that testimony has been recognized in Pereira, where the victim said, "Personally, I was angry, a little bit disgusted." The court found that to be unequivocal statement of disgust. Contrast case, a good one is Militello. There's footnote 4 where a victim testified, "Disgusted, I guess." They found that was a...
Was it on his own behalf that he was disgusted, or was it out of concern for the women who...
And that brings me to the
testifying.
second point, Justice Lang, that the victim explained how the circumstances surrounding that exposure impacted his own negative emotions,
So
but
the
not
police
just
The police
disgust.
officer was the victim.
He was, but not just his own disgust, but his concern also for someone else. I would argue that any allegation of a vicarious feeling was actually an expression of his own emotion of concern. The officer can be concerned that someone is being victimized, and that's exactly what he said. I was concerned that the females that were sitting on the bench were being victimized by the behavior, and it appeared to me that he was attempting to show his penis to the females who were sitting on the bench.
Was there, in this case, was there any effort to talk to the females?
There was, and that brings me to the 4th point. I'll jump ahead because I think that's actually the strongest point, and the fact or factor that is most consistent throughout the decisional law in Massachusetts. The victim's immediate physical reaction to the open and gross exposure was not to run after the defendant and tackle him. It was to immediately, for 5 seconds, try to talk to those 3 women who were sitting on the bench, who were 5 feet away from him at midsection level who had been exposed to the defendant's penis. He was unable to communicate with them, and it was only after that that he started chasing after the defendant. So his first...
He was unable to communicate with them because?
It was objected to and sustained. There's an indication that they did not speak English. That's not part of the evidence, but that's what happened in the record. All of the cases in the appeals court, there's a strong presence of immediate reaction to the exposure to support a significant negative emotion. In Wardell, which was this court's case, the victim rushed out of the house after the exposure. In Gray, the victim acted swiftly and purposefully to stop and identify the perpetrators to police. In Palucci, the appeals court evaluated the victim's immediate reaction and concluded that she had been upset based on that immediate reaction. In Militello, the appeals court sort of took a different view and found that because the boys did not immediately react to the open and gross exposure, but only the next morning told their parents about it, that they did not experience the significant negative impact.
Does it seem like a disconnect to you that the boys in Kessler saw an adult masturbating, but that was not sufficient to establish the shock and alarm? But in this case, we just have the display of a penis, and the adult male is disgusted, and that's enough for a conviction.
In terms of explaining it per case law, I don't think there's a disconnect, because in Kessler, this court cited Gray, Palucci, Wardell, cited cases where the victim had immediately physically removed themselves. And the Kessler court said, well, because these kids stayed put, because their grandmother had to call them twice to come back over, they were not immediately shocked. I don't agree.
But the point I'm trying to make is, isn't the act that the person engages in relevant to whether or not they're going to be shocked and alarmed? And it's just kind of hard to see how an adult male is going to be shocked and alarmed by a 2-second viewing of a penis, and these two teenage boys are seeing acts of masturbation, and that's okay.
Sure. So I have twofold answer to that question. The first is that I don't think the adult male, just because he's a police officer, just because he's an adult male, just because he's seen a penis in the locker room, all distinctions that the victim in this case made, is immune from human emotion. He's not immune from his own personal disgust. He's not immune from concern for someone else being victimized. In terms of the children, the court just found that nervous giggling did not signify a sufficient negative emotion. I think what Your Honor is getting at is that there could be a problem in this fifth element, and I would encourage the court to go back and look and see where impact actually ever came into this case.
But it sounds like, well, let me ask you, when does sort of objective assessment of the action of the suspect or defendant come into this? Is the crime and the difference between the lesser crime totally defined by what the subjective reaction of whomever the victim is?
Unfortunately, it could be. As we have it now, this steely determination of someone, or their just inability to express themselves and how they were harmed by this objectively open, gross, obscene conduct, will define the criminal nature of the conduct, will render this objectively open and gross conduct non-criminal. And I think that's...
Well, it still may be, what's the...
It may be indecent exposure.
Right. So the issue is not whether it's a crime. The issue
Is a crime.
The issue is which crime.
And the degree goes to the fourth element. I read the fourth element as an intent and manner element, that the defendant intended to expose himself in a manner that would offend someone. So he's intending to do this. I think that the fifth element, and I track the fifth element back, it seems like the horse may have bolted the barn. considering that in 2004, this court in Kessler talked about the fifth element a lot. But the fifth element sneaks into this crime between Fitta and Gray. So Fitta in 1984 and Gray, an appeals court case in 1996. Gray cites Fitta. Fitta does not have an impact element. Fitta cites Wardell. Wardell does not have an impact element. Gray cites Fitta in a 1989 jury instruction. In that 1989 jury instruction, somewhere the fifth element, that subjective impact element, comes into play. It is based on what I think is a misreading of Wardell. Wardell discusses what openness is, and it's just a turn of phrase that's right in the middle of Wardell talking about openness, that it only needs to be to one person, only needs to shock and alarm one person.
This is effectively, in terms of the elements, a common law crime. I mean, because it's us who defines. And isn't the last element meant that there really is a victim who's seriously or meaningfully harmed?
It does. I wrote a 16L letter to the court referencing Commonwealth versus Botev. In Commonwealth versus Botev, it's an excellent opinion by Justice Cohen in the appeals court, where they're talking about the engraftment of this impact element on what is essentially an act-based element. It's a crime against public decency.
What's the site?
Botev.
I'm
Bear
sorry.
with me one moment.
You have a letter. I just thought you might have it right there.
It's a letter we haven't received yet, I don't
Yeah,
think.
I don't, have you seen it?
I didn't get one.
No, it's a letter you filed?
I did. I filed it last week, and I apologize.
Okay, we don't have it, so you'll have to follow up with Clerk Keneally with regard to that, because
I
don't
did,
think-
I did receive it.
You did?
It
Oh.
is, I'm
Yeah.
sorry, 79 Mass Ave Court at 281, and it's a
it.
2011 case, thanks. But what Botev essentially says is, it's act-based, it's not victim-based. Botev was a case where the defendant lewd and indecently exposed himself to two victims. The defendant said, "You can't charge me with two crimes, it's only one act." Justice Cohen aptly noted that if someone exposed themselves to 37,000 people at Fenway Park, he wouldn't be charged 37,000 times because this is an act-based crime. I think reading Botev, rereading Wardell, and rereading sort of the case law about how this fifth element is sort of crept into this crime sort of reveals that the fifth element is essentially unnecessary and may, again, render what is criminal conduct non-criminal. I just, if I may have one more moment to note why the evidence in this case is sufficient. The officer, again, this is not the perfect test case where an officer just stands up and says magic words. He explained the circumstances surrounding his words. He explained why he was concerned for other people, which is in and of itself another negative emotional consideration. He explained time, place, and manner. And this court in Quinn has noted that time and place will play a role, that seeing someone's penis in a locker room is completely different than seeing it in a public place, where the exposure would be wholly unexpected and it may cause that shock and alarm. As to, and I'll end on this, but as to the dissent in the appeals court case, most, if not all of it, goes to the weight and the credibility and not the sufficiency of the evidence. These arguments that the victim was an officer and therefore he couldn't feel disgust, that he came to the exposure, therefore he couldn't actually be shocked and alarmed, are excellent closing arguments to make to a jury to try to impeach the officer's feeling, but they're not sufficiency arguments. And unless there are any further questions.
And am I correct that the crime for which he was convicted is a predicate for the SDP?
I don't know that off the top of my head.
Yes.
I know that it takes, I think, 2 convictions to have to register on the sex offender registry, I believe. I don't think you have to register based on one, but Mike can certainly investigate that and send the court
I think your brother agrees with you. 2, is that right? 2.
Okay, thank you.
Thank you.